We recently got a call from that listener who's really at her wit's end. Seems the neighbor has several diseased or dead trees on the property that they've been made aware of by certified letters. Now, that would be, actual delivery, actual notice of it. In fact, a few years ago, 2 trees fell on our listener's property, damaging the fence, and it was quite a few $1,000s to remove them, of which our listener refused to split the cost with, and the neighbor covered it. Now the home is for sale, and the other home is for sale, and our listener sent another letter not only to the seller but to the listing agent as well about the additional 5 to 6 trees that are leaning toward their property. Can you give our listener some advice on what to do, since the home will soon belong to a new owner?
And they probably called their insurance company that said ultimately you're going to get, you're going to, now that you have been notified, right? So either take them down, or if it happens, that insurance company is going to pay them. So what will happen is, when it's you don't notify them and it happens, your insurance company will cover it, and then they're going to want to subrogate, which is they're going to want to go after the neighbor's insurance company. The neighbor's insurance company will say, well, you didn't notify us and we didn't know. And so it's like one free pass. But now that you've notified them, that insurance company would be on the hook for it. And so there would be a subrogation claim from one insurance to another. Subrogation means I'll pay this claim, but I'm coming after you, the next door neighbor's insurance company. And they would sort that out and they would pay for it. Well, that's how it's supposed to work. And then if people or insurance companies decide they aren't going to do it, and one insurance company will decide if they're going to bring a lawsuit against the other insurance company. And they need legs to stand on, and that certified email or certified letter signed by the other side will provide the notice, and that should be the legal basis to win it.
She knows it's listed. She knows the seller. She knows the agent. So I think the listing broker. So I think her sending notice to the listing broker, that at least that listing broker might be held to the standard of disclosing the adverse material defect, or whatever you might call it in this case. How do you think that would work? Because I think including the other agent would force the agent to make sure that the buyer and the buyer's agent are aware of the particular situation. What's your opinion on that?
I think, it comes down to, I guess you're required for a material defect. And so is that a material defect or not, right? And so you want to be careful. You want to be careful, too, from the neighbor's point of view. You don't want to interfere with some kind of contract. I mean, buyers have the choice to go out and review and take a look at the property and see what's going on. And if they become, they get to visually see, hey, there's some dead trees there. What's up with that? And if the seller is just completely not saying anything, something happens, the insurance company, everybody can pursue who actually was the one who really knew and had a duty to disclose. But you don't want to go too far, because then it becomes interference, tortious interference with the contract. So you got to be a little bit careful on how far you reach out to somebody new coming in.
So interestingly, it sounds to me like what you're saying is that this lady is doing everything she needs to do to put everybody she can on notice, but she probably needs to be careful going directly to the buyer's agent or directly to the buyer, because somebody could say, hey, you were specifically trying to mess with my contract and you're not supposed to do that. Because it is a buyer beware state. Georgia says, hey, your job as a buyer is to do all the investigation, so it could be totally up to you to find it.
And then when the new buyer comes in, you send that new certified letter to the new buyer.
Once they own it.
But it says, hey, your trees are diseased.